opposed to quashing of a eligible proceeding initiated by the defects of complainant adapt lady, the major lady, out of a love relation, out of an incident of a frustration of outcome of love relationship, a continuous love relationship, and being frustrated with the same process, she had lost the affair against the petitioner, who is dhara and fiancé. Since the marriage was not ultimately again, that's why his affair has been registered and all. The initial matter was admitted and stay was granted. Appeal was served. On 2 occasions, appeal was served, but none of the occasions she appeared in this court, and the immediate charges has been filed accordingly. In nutshell, the issue before your lordship is whether it was served upon the defect of office. Yes, served upon his address. It was. What is the service? On that day before yesterday, lordship had taken the unit of service. Thanks. Yes, are you ready? Good. Before your lordship, whether a marriage, in a continuous love relationship and a consensual sexual, amorous relationship, when a marriage is not in place, whether it amounts to an offence or not, this is the crux of the matter. The law laid down by the Honorable Apex Court consistently and as well as our Honorable High Court in significant is that it is not at all an offence. Because when a consensual relationship is being continued between 2 adults, with the risk of frustration of any probated result, that does not so facto means that any of the boy has committed an offence of rape. Because the law is that when both adults being entered into a consensual relationship, and out of that consensual relationship, and when a sexual relationship is occurred once or more than once, and on a premise to get married ultimately, but when the marriage has not been taken place, it cannot be said that the law it has been offence of rape and all. This is the second position of law. I would like to rely upon a series of judgments passed by the Honorable Apex Court as well as Honorable High Court, and on that score, applying this law, a series of matters have been passed, charge sheet, FIR, whatever, has been passed, and I am ready with all judgment. This is one kind of argument. I am giving a nutshell overview of the intention. Second thing is, Lordship, that the significant feature is this: after this affair of which lady has ultimately communicated a communication to the petitioner boy that she has committed a wrong, she may be excused, and this communication has been made. I brought all these things on record. Number 4 is this lady particularly has been found to indulge in the similar set of relationship, and when the same relationship comes into frustration, then she triggered a second FIR against a subsequent FIR against that particularly person when the marriage has not been culminated. So this is on record that she has been found in a regular habit of such continuation of such relationship, and when the relationship did not arrive in probated result, then she is in habit to register FIR like that. This habit I find from the record. I brought also all these things on record. I brought all these things and then I annexed all these things. This is the last case. Should I place the judgment and law, or should I place the FIR case and my case and all? Show me the FIR first. So 34 of my application is the FIR. 38. Both are error. Got it? 38 page. And it's just before. FIR letter submitted letter of information dated 16th of October 2021. She has alleged that বিগত 10/2/2019 তারিখ
Yes, I have read that. Yes. Charge sheet submitted?
Yes, charge sheet submitted. Charge sheet under section 417 and 376.
Charge sheet page?
Charge sheet page. Page 44. Charge sheet submitted with the Lanet Court below on 23rd of August, 23rd of February 2022.
Yes. Show me the law. Yes.
The paragraph number 4 and 3 and 5. The fact in nutshell was that the party chose to have a physical relationship without marriage for a considerable period of time. For some time, the party fails apart. It can happen both before or after register. Thereafter, also 3 years passed when the respondent number 2 decided to register in FIR. This was the fact. Honorable Apex Court subsequently hold in paragraph number 5 that we fortified to adopt the course of action by the judicial due in so and so 2019-9 Supreme Court 608 that titled Promote Sullivan's Power versus State of Maharashtra, where factual scenario where the complainant was aware that there existed obstacle in marrying the accused and still continue to engage in sexual relationship. The Honorable Apex Court, the Supreme Court was the FIR. A distinction was made between a false promise to marriage, which is given on understanding by the maker that it will be broken and breach of promise which is made in good faith but subsequently not fulfilled. This was in the context of Section 375 Expansion 2 and Section 19 of the Indian Penal Code 1860. The criminal case is accordingly allowed. Improved judgment is set aside and proceeding pursuant to FIR taken so and so stand fast, leaving parties to bear their own part. So this was a case registered under Section 376 and 417. Subsequently, Honorable Apex Court laid down following the laid down law. The sixth was the least impaired possible. This is number 1. Number 2. following the same principles of law, as you can see at page 3. The parties, this is also said, the parties chose to have physical relationship without marriage for a considerable period of time. For
Same judgment.
What's it?
Same judgment.
Sorry. Second law. There are 3 to 10. Kindly see, there are 3, this is there are 10. 2 and 10. The paragraph number 10, the first page, is maybe read as para 3 because it is a practical mistake. Para 3 deals with the fact and victim marriage. The para 3 victim marriage that the applicant offered to marry the victim on the understanding that the applicant would marry the victim. There was physical intimacy between the applicant and victim, which resulted in pregnancy, which had to be aborted. We are not concerned with the dispute between the parties. The case made out by the victim itself against the applicant does not make out any offence of rape against the applicant. There is nothing on the basis of which it can be inferred that the applicant held out any false promise with any intention from the very inception to marry. So this was the fact. Subsequently, the FIR has been dealt with, and paragraph number 5 followed the law of the Honorable Supreme Court laid down in Shrivan Power, first state of Maharashtra, and then Lordship in paragraph number 3, last paragraph, prior to paragraph number 6, the relevant portion can be seen, and to summarize the legal position that emerged from the above cases, the consent of women with respect to section 375 must involve an active and reasoned deliberation towards the proposed act. To establish whether the consent was vitiated by misconception of fact arising out of a promise to marry, 2 propositions must be established. The promise to marry must have been a false promise which given in a bad faith and no intention of being adhered to at the time it was given. The false promise itself must be of immediate relevance or bear a direct nexus to the woman's decision to engage in sexual act. The allegation, paragraph 6, the allegation in the FIR indicates that the relationship was consensual even though it may be based on an offer of marriage. Paragraph 7, moreover, admittedly, applicant had not declined to reside from the offer to marry, but he had short time, contending that he was 24 years of age and the salary of 11,000 per month, which was not sufficient to maintain the victim. Charge sheet filed against the applicant and his party parents under section 376, 373, 420 and 34 of Indian Penal Code. So registered applicant filed an application for discharge rejected. Applicant's parents have been discharged. Intimation application filed by the applicant has been rejected by the judgment and so expressing no case of rape under section 370 is disclosed against the appellant. Appeal is allowed in part. Discharge the offence under section 376 impute dhara is accordingly set aside only to the extent incited above. Later proceeding. So this is the consequence. So false promise and marry, false promise and to have cohabitation and subsequently not to marry is not an offence laid down by the Honorable Apex Court also. In this case. Second, third one is paragraph number 7, 8, 9, 12 and 14. 7, 8, 9, 12, 14. Judgment reference to look at that. কি নামটা বলবো Somur, Karwar, Vachas, Para 7. Also conditions. The parameter governing the exercise of jurisdiction 482 that I am not discussing the power of section 482 right now. Also I am ignoring this paragraph 7 because it deals with the power of section 482 quashing and all. Paragraph 7. Should I read out?
No, not necessary.
Paragraph 7 and 8. 8 the same. 9. Paragraph 9, penalty. So and so judgment, particular judgment, the two judges bench of this court, while dealing with the similar facts as present case, reiterated the parameter laid down in volume 1. This is also the power of the court. And now we are quashing. And paragraph 12 and 14. 12. In the present case, the issue, paragraph 12, had to be addressed by the High Court was whether the assuming all the allegations in the charge sheet are correct as they stand, and offence punishable under section 376 Indian Penal Code was made out. Admittedly, the appellant and the second respondent were in consensual relationship from 2013 until December 2017. They are both educated adults. Second respondent during the course of the period got married on 12th of June 2014 to someone else. The marriage ended in a divorce by mutual consent on 17th of September 2017. The allegations of the second respondent indicates that the relationship with the appellant continued prior to her marriage, during the subsistence of the marriage, and after the grant of divorce by mutual consent. On paragraph 13, next, in this backdrop and taking allegation in the complaint as stand, it is impossible to find in the FIR that or in the charge sheet the essential ingredient of an offence under section 376 of Indian Penal Code. The crucial issue which is to be considered is whether the allegation indicate that the appellant had given a promise to the second respondent to marry at the inception was false, or on the basis of which the second respondent was induced into a sexual relationship. Taking the allegation in the FIR and charge sheet as they stand, the crucial ingredient of the offence under section 376-75 of Indian Penal Code are absent. The relationship between the parties are purely consensual nature. The relationship, as noted above, was in existence prior to the marriage of the second wife respondent and continued to subsist during the term of the marriage and after second respondent was granted a divorce by mutual consent. Now the court, the High Court in the course of judgment has merely observed that the dispute arises to question of fact and cannot be considered in the application under section 482 of the CRPC. Is demonstrated above in the analysis, the fact as stand which are not in dispute would indicate that the ingredients of the offence under section 376 of Indian Penal Code were not established. High Court has therefore proceeded to dismiss the application under 482, proceed on a completely responsive basis. We accordingly allow the appellant set aside the imposed judgment and order of the High Court dated so and so in an application under section 482 number so and so. The application under section 482 shall accordingly stand allowed. The case crime number so and so registered so and so is in the above case number so and so in the so and so taking cognizance of the charge sheet shall accordingly stand quashed. So this provides on the same set of facts as 376 and 470. The case was involved. High Court turned down the prayer. Honorable Supreme Court discussed the power of High Court and decided in favor of the accused person and quashed the prosecutor. This is third. Fourth, it is you. हाँ, ये तो क्वेश्चन कुछ जगह नहीं लेगा. Number 2, it is a monster thinker. That's a set of Japan. The Honorable Apex Court under the Honorable Judge Noriman, I.F. Noriman, in paragraph number 17, 20, and 21, beautifully dealt with the law. Para 20 guys in this judgment. Para 20, we have no hesitation in concluding that consent of the prosecutors was but a conscious and deliberated choice as distinct from an involuntary action or denial, and which opportunity was available to her because of her deep-seated love for the appellant, leading to her to willingly permit him liberty with her body, which accordingly normal human beings are permitted only to a person with whom one is deeply in love. These observations in this regard in the Supra are considered relevant. It is usually happened in such cases where two young persons are madly in love. They promise to each other for several times, and they come what may, they will get marriage. As stated by the prosecutors, the appellant also made such promise and more than one occasion. In such circumstances, the promise loses all significance, and particularly when they are overcome with emotions and passion, and find themselves in situations and circumstances where they, in a weak moment, succumb to temptation of having sexual relationship. This is what appears to have happened in this case as well, and prosecutors willingly consented to having sexual relationship with an appellant with whom she has deeply in love, not because she promised to marry her, but because she also desired it. In these circumstances, it would be very difficult to impute to the appellant knowledge that prosecutors had consented in consequence of a misconception of fact. Arising from this promise, in this event, it was not possible for the appellant to know what was in the mind of the prosecutors when she consented, because there were more reasons than one for her to consent. In conclusion, we find the conviction of the appellant to be unsustainable and set aside the same, and the appellant is acquitted. He is directed to set aside the liberty forthwith unless so and so. That's it. It is admittedly this case law relating to a conviction which has been set aside. Applying the principles of law laid down, I just laid down by the Honorable Apex Court. I am just relying upon this judgment only because the law laid down by the Honorable Apex Court has been reiterated in this case and beautifully dealt with by Justice Noriman. Now, subsequent paragraph number 18, 19 and 22. Paragraph 18. In so far the assertion made by the complainant prosecutors in her first complaint dated 16th of February 2007 is concerned, it is apparent that on the basis thereof, first information report number so and so was registered at police station New Delhi. In her first complaint, the complaint prosecutors had alleged that the appellant accused had called her on her phone at so and so time and asked her to meet at Lodi Colony, New Delhi, where she reached there. He drove her around in a car, and he also offered her to cold drinks, Pepsi, containing a poisonous intoxicating substance. Having consumed the cold drinks, she has started to have felt inebriated, whereupon she took advantage of her and started misbehaving with her, and also touched the breast, or insofar as the instant aspect of matter is concerned, the presence of the complainant possibly so and so as well. The appellant accused as alleged the place of occurrence on the night of 5th of February 2007 at 8:45 p.m. has established to be false on the basis of mobile phone details of the parties concerned. Details in such respect have been summarized in paragraph number 8. The same were not being repeated for the reasons of brevity. The proof of aforesaid factual matter must be considered to be conclusive and all intents purpose, specifically in view of the observation made by so and so in judgment. Thereafter, paragraph 18, 19 and 22. 19. Paragraph 19. The proposition of law pertaining to the quashing of criminal proceeding initiated against the accused by High Court by a High Court under section 482 of the Code of Criminal Procedure has been dealt with by this court in Rajiv Thapar versus Mohanlal Kapoor in SLP number so and so.
That is another issue.
Does it?
That is 482 issue.
Yes, 482. Now the concluding part is paragraph 20. Paragraph 22. Based on this holistic consideration of the facts and circumstances summarized in the foregoing two paragraphs, we are satisfied that all steps delineated by the court in Rajiv Thapar case stand satisfied. All steps can only be answered in the affirmative. We therefore have no hesitation whatsoever in concluding the judicial conscience of the heart ought to be persuaded on the basis of a material available before it, while passing the imputed order to quash the criminal proceeding initiated against the accused appellant in exercise of the inherent power vested in the under section 482 of the code. Accordingly, based on the conclusion drawn here in above, we are satisfied that first information report registered so and so under section 328, 354, 376 of the Indian Penal Code against the appellant accused, and the consequential charge sheet dated so and so, and also the framing of charges by the learned additional session judge, New Delhi, on so and so, deserve to be quashed. The same accordingly quashed. Now here the charge was framed and thereafter quashing preferred, that was also quashed. Applying the same principles of law. So the very judicial judgment 2014, the Honorable Apex Court dealt with the same thing. This case also 376 to